Hi, good morning, everybody. My name is Sahil Shore. I'm a partner here at Gowling WLG Canada LLP. Thank you for joining us this morning on our webinar from the lessons on R versus Greater Sudbury case that went to Supreme Court of Canada. And we are here to speak to you this morning about the implications of the decision on your construction project, both from a construction contract perspective and the occupational health and safety perspective. I see that the numbers are increasing for the folks who are joining us online. So if we could go to the next slide, please. So we are going to record this webinar and we are going to post a link to the recording on our website. And if you are signed up to receive a version of our insights, either through occupational health and safety or through our building brief, you will receive a copy of the recording. We would ask that you please use the Q&A tab at the bottom of your screen to ask us questions throughout the session. Me and my partners and colleagues, we are monitoring the Q&A session, and we will answer the questions either live in the Q&A function or to bring your questions to the panel. And most importantly, thank you for joining us. Next slide, please. So the agenda at a high level for the next hour is we're going to talk about the journey of the case. We're then going to speak about what is an expanded definition of an employer, the role of the due diligence defense, and then my colleague Michael is going to pose questions to me and my partner Tushar pertaining to the implications of the ruling and what, if anything, you should be doing now to manage the risk. Next slide, please. As always, a legal disclaimer that we're talking to you at a very high level in terms of what the case is. And this is not intended to be legal advice. And if you have specific questions about your project, if you have specific questions pertaining to your health and safety policy, if you have specific questions about your safety management plan and its integration into your project, please reach out to one of us. Next slide, please. So I'm joined by Tushar and Michael. So Tushar and Michael are going to speak to you first about the case itself. So over to you, folks.
Thank you, Sahil, and good morning, everybody. I hope the seasonal allergies are not affecting you as much as they are affecting me this time of year. So we'd first like to take you through the judicial journey of this entire saga that spans 6 years. I'm sure most of you are familiar with all the decisions here, but it's important to reiterate those important facts and understandings as they'll form a basis of our Q&A session shortly. So what was at stake in this entire 6-year saga? Well, it was the very definition of owner responsibility in the construction industry, specifically an owner who is also an employer. And what is interesting is that this wasn't a case where it was just about one city, one municipality, one contractor, and it just concerned those contracting parties. It really concerned how we understood how an owner/municipality in the construction industry was forced to rethink how to navigate workplace health and safety laws. And now, after many legal twists and turns, 6 years that spanned one trial, 2 decisions of the Ontario Superior Court, 2 decisions of the Ontario Court of Appeal, and a Supreme Court of Canada decision, we are finally at that legal conclusion. Next slide, please. So what we saw in this case was a typical, what we call industry standard contractual arrangement. The city of Sudbury was the owner. They recognized they needed road and water main repair work. And of course, they reached out to the public to see who was the best contractor for that job, for quote unquote, the expert to do that job. So the city was the owner, and eventually they contract with a general contractor. So the general contractor undertakes the project as a constructor under the Ontario Occupational Health and Safety Act to undertake those repairs. So the general contractor assumes full responsibilities, which is typical and for all sub-trades under its control. So there are three main components. The general contractor controls the project. They ensure compliance with the Occupational Health and Safety Act, and they file notice of the project with the Ministry of Labor. Next slide, please. So the key facts here is that the city's role is limited to monitoring the project. This is typical. I think of the city as, the customer, as if I were contracting out for someone to fix cabinets in my house. They're the experts. I don't have control over that project. I monitor it. So what we saw is that there was quality control from the city's perspective. Contract compliance, the city had inspectors that they would send to the project to ensure, workmanship, defects were all sorted out. The project was progressing as planned. These inspectors were directly employed by the city, but they didn't direct or control that project. So unfortunately, in 2015, there's a tragic accident. A pedestrian is struck and killed by a road grader, and the pedestrian was crossing a traffic light in that construction zone. So what happened was there was a non-compliant operation by the employee of that general contractor. So of course, the Ministry of Labor finds out and charges both the general contractor and the city with various violations of the Occupational Health and Safety Act. So importantly, before the city's trial, the general contractor pled guilty. And what was interesting is that the city was charged as both a constructor and an employer under the Occupational Health and Safety Act. So it's this two-pronged component that was really interesting to us in this area. Next slide, please. So the start of the judicial journey, what the focus was at the trial decision was, what is really the purpose of the coverage of the Occupational Health and Safety Act? So the city was ultimately acquitted by the finding that it was neither a constructor nor an employer. So the Crown wasn't able to prove beyond a reasonable doubt that the city was an employer under that traditional understanding of the Occupational Health and Safety Act. And the reason I use the words beyond a reasonable doubt is because violations under the Occupational Health and Safety Act are quasi-criminal violations, and thus the burden of proof is much higher than we typically see on a balance of probabilities. So the Crown appeals again, and they asserted again that the city was liable as both a constructor and an employer. And the Superior Court of Justice upheld the trial decision. But what was interesting is that the court remarked on a practical understanding of the construction industry. In the court's view, if they were to endorse the Crown's stance that the city was an owner and employer, it would substantially change what the practice is throughout Ontario on construction projects. So in the court's view, the city was not an employer such that it was liable for those breaches of the Occupational Health and Safety Act. But what was interesting, and which I will pass off to Tushar in a moment, is that the Ontario Superior Court did not make any comment on whether the city had been duly diligent. And this is important as I pass it off to Tushar.
Thank you very much, Mike and Sahil, for the warm introduction. Good morning, everybody. Joining you from sunny Waterloo region today. And thank you all once again for joining us today. My name is Tushar Anand-Sagar. I'm a partner in our ELE group specializing in labor relations and, of course, occupational health and safety. Okay, so let's take a look at this Ontario Court of Appeal decision in R versus Greater Sudbury. Picking up where Mike left off, the court actually refused to consider evidence regarding whether the city had actual direction or control over the project. It was focusing squarely on this issue of whether or not the municipality was a quote-unquote employer, and that issue was not at all determinative at this stage. The court actually reaffirmed under the OHSA that liability for an employer is strict, and that once an entity is classified as an employer, it bears the burden of showing that it took every precaution reasonable in the circumstances to keep the workplace safe. And so following this Court of Appeal decision, the city of Greater Sudbury was actually found to be a quote unquote employer for the purposes of the entire road building project. Second, that the entire construction project was deemed a workplace as defined by the OHSA. And this was the Crown's second appeal, so it was partially successful. The matter was, at the end of that proceeding, remitted back to the trial level for further disposition. And the Court of Appeal's decision, further to the comments that were made by the Superior Court, had substantial implications for municipalities, project owners, constructors, contractors, GCs, regarding all of their obligations under the OHSA. And so the city of Greater Sudbury appeals and goes on to the Supreme Court, as you'll see from the current slide. So following that Court of Appeal ruling, the case goes on before our highest court, and the result was an exceedingly rare 4-4 split decision, which then means that the appeal is dismissed by default. So in effect, the Court of Appeal's decision, which sent shockwaves through the construction sector, at least in Ontario, it stood. And so the Supreme Court was evenly divided on one key issue: whether a project owner like the city could be held liable under the OHSA as an employer, even though it had delegated day-to-day operational control to an independent GC or a constructor. And because there was no majority at the SCC, the legal uncertainty remained, particularly for municipalities and other owners who engage third-party constructors all the time, but they do retain certain project responsibilities. We'll get into that a little bit later on. So the split actually left intact the Court of Appeal's finding that the city was an employer, the construction site was a quote unquote workplace under OHSA, and that the city could be charged for a breach of the OHSA that occurred at the workplace at a point in time when they weren't even on site. Next slide, please. So this is interesting. We're getting briefly into some of the rationale for the court's decision and the reason for the split. Justice Martin wrote one of the leading opinions in the Supreme Court's split decision. She took the view that the city was quite clearly an employer under the statute, regardless of whether it had day-to-day control over the construction site. In her analysis, the OHSA did not require direct control to impose the duties of an employer. The city could be charged, and it was sufficient that they had sent quality control employees on site. Control aspect was irrelevant at this stage of the analysis. She emphasized that the OHSA imposes a broad and proactive duty on all workplace parties to ensure workplace safety. And in her view, allowing owners to skirt liability simply because they had delegated control created a pretty dire situation overall for employees under the statute. So essentially, it would undermine the Act's proactive and purposive approach. It essentially runs contrary to the belt and suspenders approach of the legislature and the courts to the OHSA and enforcement under the OHSA. And so she also rejected the argument that overlapping responsibilities between owners and constructors somehow created unfairness. She maintained that the statute contemplated multiple employers with concurrent obligations on complex project sites. Again, the priority being employee safety and more coverage rather than less. So ultimately, Justice Martin would have upheld the city's conviction, reinforcing a strict interpretation of employer responsibilities under the OHSA. And the only remaining defense would be the defense of due diligence, which had not been adjudicated. Next slide, please. The dissenting reasons are just as interesting. Here we have Justices Rowe and Obonsawin, who stated that the city should not be held liable under the OHSA simply because it met the definition of an employer. They took the view that the plurality of the court's focus was too heavily predicated on on technical definitions, and did not focus enough on the practical realities of construction and project sites. The city had no direct control or supervision over the day-to-day work, and they emphasized that overlapping duties on multiple parties without regard to actual control could create confusion, duplication, and potentially unfair outcomes. particularly for owners who are typically the parties that are least directly involved in managing site safety. The dissenting justices also cautioned that the majority's approach risked diluting accountability for any specific party by spreading the responsibility for OHS safety too thinly or too broadly, rather than targeting the parties that are best positioned to ensure compliance, which is essentially what the historical approach had been. And so in their view, the OHSA would be interpreted in a way that reflected the actual, or ought to be interpreted in a way that reflected the actual division of responsibility on a work site, not just these technical definitions of owner, constructor, employer, et cetera. And so they would have acquitted the city, finding that it was not liable under the circumstances. Next slide, please. So following the Supreme Court's split decision, the case was remitted to the Ontario Superior Court once again to determine whether or not the city could establish a due diligence defense under the OHSA. And so the Superior Court, unsurprisingly perhaps, once again found that the city had met the test for due diligence, which requires an employer to prove on a balance of probabilities that it took all reasonable care in the circumstances to avoid a contravention of the OHSA. That's sort of the first arm. And secondly, implemented a proper or compliant system to prevent workplace accidents and took reasonable steps to ensure its effective operation. In this particular case, the court found the city satisfied both of the branches of that legal test. The court pointed to the following key factors. First, the city did not exercise operational day-to-day control over the road building site. Second, it retained a qualified constructor with a strong 40-year compliance history. Third, it had clear contractual provisions assigning health and safety responsibilities to the contractor. Fourth, it conducted reasonable oversight through inspections and ongoing project monitoring. Some other observations, the court noted that although the city didn't have day-to-day control, it was still required to anticipate foreseeable risks and implement safeguards accordingly. And it met this obligation by ensuring that the constructor had its own occupational health and safety policies. It did implement safety training and had incident response protocols in place. So those features were present. Had they not been present, we could have been looking at a substantially different outcome. The court also, on the previous slide, please. The court also distinguished between delegation versus the abdication of responsibility. And so the court emphasized that due diligence does not allow an employer to fully abdicate its duties and responsibilities under the OHSA. However, in this case, the city's delegation to a competent and experienced constructor, coupled with its contractual expectations and monitoring practices, it actually showed that the city had taken proactive steps rather than passively shifting blame to the GC in this particular instance. And so the city was actually found by the court to have in place what it determined was a reasonable system for ensuring safety compliance. And this included periodic site visits for quality control, ongoing communications with the contractor, written documentation of safety roles and responsibilities, and of course, the features of the contract which delineated these points. The court found no evidence that the city had been negligent, willfully blind, or somehow indifferent to safety on the project. And there were no complaints or deficiencies flagged prior to this very unfortunate incident occurring, which further supported the claim that the city had actually exercised due diligence. The court then went on to conclude that the city had implemented a reasonable system of oversight, and it took steps to prevent foreseeable risks. It maintained contractual practical safety measures. It distinguished the city's conduct from cases where employers failed to supervise or simply delegated authority blindly. There was no evidence of that whatsoever, or a failure to act on known risks. And these factors demonstrated that the city had acted with a level of care expected under the OHSA, and that the charge of a breach of the statute as an employer was therefore dismissed on the basis of the city having met the standard of due diligence under the statute. It should surprise nobody that the Crown appealed the Superior Court's decision. And this one's very brief. Next slide, please. On March 31st, just a couple of short weeks ago, the Ontario Court of Appeal reviewed the court's decision and denied the Crown's request for leave to appeal the Superior Court's remand decision. this dismissal essentially brought to an end nearly a decade of litigation since this fatality occurred in 2015. And the city's acquittal now stands. The legal saga, if we can say it that way, is effectively over, which marks the conclusion of one of the most closely watched OHSA prosecutions in recent memory. I will turn back over to you, Mike, for some key takeaways.
Thank you, Tushar. And I think what we can really see from that is the emphasis on direction and control and reasonableness of due diligent measures. And really the key takeaway here is that Ontario's construction industry can now take a deep sigh of relief. Throughout this last decade, there was there was doubt on whether owners could insulate themselves from liability under the Occupational Health and Safety Act when they cede that control. And I think what affirms now is that you can delegate and exercise due diligence and best protect yourself. You're not automatically on the hook for a constructor's failures. So in terms, control is a key defining factor, but it's not everything. As we see in this case, you need to truly cede control. And that decision of the Ontario Court of Appeal now is the final word on that it solidifies that due diligence can be established when you cede that control. But you must be able to demonstrate that you entrusted that work to a qualified constructor. And again, delegation is not a free pass. The city was able to defend itself because it selected a contractor with experience, because it reviewed safety records, because it maintained oversight, it sent in quality control personnel. You still need to take those proactive steps. So again, delegation is not a free pass, but it certainly helps. So as every lawyer will say, an ounce of prevention is worth a pound of cure. What we can see from this overall is that failing to proactively manage legal risk can be catastrophic. Be proactive, seek legal counsel, be diligent, make sure you document those steps and best insulate yourselves if a failure ever does happen. Reputational risk sometimes is even more important than legal risk as well. And so now that legal conclusion is there, and we wish to open it up to a preset of questions of this expert panel between Tushar and Sahil. And during this time, I do encourage the audience to submit any questions they may have, as we will open it up as well to those questions soon thereafter. So I think, for this first question, Tushar, you can likely come at it from the statutory component perspective, and Sahil you're on the ground level dealing with contracts. So what is the difference between employer and owner under the Occupational Health and Safety Act?
Thanks, Mike. This is a good one to sort of set the stage. So the OHSA makes a clear distinction between owner and employer. And I think just to tie it back to the case, that distinction was essentially at the heart of the Greater Sudbury litigation. So an owner is typically the entity that owns the land or property that the work is being carried out on. An employer under the statute employs workers or contracts for work to be performed and has broader responsibilities for workplace health and safety under the statute. In Sudbury, the city was both the owner of the construction site and a party that contracted out the work and had staff attending on site. So it was sort of a unique situation in some senses. But the city argued because it didn't exercise direct control, it should be treated strictly as an owner, not an employer. That is a very common argument that has come up in the past. So of course, multiple levels of the courts disagreed, both the Ontario Court of Appeal and a plurality, of the Supreme Court held that the city was an employer. And that distinction matters because the OHSA imposes stricter and more proactive duties on employers than owners. That's one key takeaway from a statutory standpoint. So being classified as an employer triggers the city's obligation to show that it's taken every reasonable precaution in the circumstances, which is different from the standard of conduct that is expected from an owner. it ultimately leads to, sort of practically speaking, a full trial potential, a full prosecution potential, and extensive litigation on the issue of due diligence. So that is one kind of takeaway from a statutory standpoint. Sahil, anything to add?
Yes, certainly. No, thanks, Tushar. If we take a step back, and taking the step back is, let's talk about the project that you're taking to the market, and you're not talking about the contract drafting. What does this distinction mean as from a contract drafting perspective? And in my view, the first important thing is to recognize that ultimately the Ministry of Labor wants to know that the project and the site in particular is safe. And it wants to know that the person in charge has the ability to make sure that it's a safe project. So for our jobs in our contracts and in the project structure and in project management is to make sure that those lines and responsibilities are clear. Those responsibilities and lines are clearly defined, and they clearly assign the role to the entity, to the stakeholder who is best to take on that risk. So the first part of that is being clear about who is the constructor. So in our contracts, and even without a contract, you would want to make sure that the person in charge of health and safety is clearly assigned the role of a constructor under the contract, and they have accepted that role. And you would also want to make sure that they have the experience, the resources, and the bandwidth to manage that role. The responsibility applies irrespective of the size, scope, or the nature of the contract, all the way from a simple project to a very large project. Speaking about the larger project or phase project or much more complicated projects, you might have multiple contractors on the site. And so it's important to contractually make sure that everybody is clear who is the constructor, that they have the authority to be the constructor and control the site, failing of which the Ministry of Labor, if there's an accident, could come back and say there isn't any one party who has the control of the site, and therefore you, the owner, even though you thought you delegated everything, you are the constructor, and so you are on a hook for these charges. That's what I would say, Tushar, from the contract perspective.
And Sahil, you just alluded to it about assigning roles and responsibilities. So I'll kick it to you first. If there's anything else to add, what are the responsibilities of an employer under the OHSA, and how are they different from that of a constructor and or owner?
Yes, again, going back to the contract drafting piece, Mike, I would submit that over the last several years, I've seen drafters who are drafting these construction contracts try to draft, but I think one of the things that it always doesn't get right, at least to me, is that you could assign that responsibility or delegate that responsibility. Could you even contract out of that responsibility? And I believe that one of the primary key takeaway messages from the Supreme Court of Canada decision and the Court of Appeal decision is that the responsibility as an employer, that will always be for the owner. That's how I understand it, and that you cannot delegate all of that role. The employer / the owner cannot delegate all of their responsibility on a job site to a contractor, wipe their hands off, and walk away from the project. But I think what is important is who is an employer, and it in my view, it's a matter of law that it cannot be assigned or transferred. But with that being said, there perhaps could be some of the duties of an employer that could be delegated to the contractor, for instance. But that doesn't change the underlying responsibility that an employer could still be held responsible for the safety obligations of the workplace. Tushar?
Absolutely, and to build on that, Sahil, you touched upon the concept of responsibility, right? And I think the The OHSA has various, let's call them buckets, in which different entities in a construction worksite context are placed. So the employer, there's actually a question in the live Q&A about the changes, potential expansion of employers' responsibilities and obligations. Those obligations are about as broad as they can get already. I wouldn't say that they have been expanded. I would say that they've been sort of refined and applied to the owner category, which historically hasn't happened. So what is an employer responsible for? They have to keep the workplace safe for workers under their supervision and their employment. The workers have to be provided with appropriate training, supervision, and equipment. So on the ground duties and responsibilities. They, PPE, stuff like that. They have to take every precaution reasonable in the circumstances for the protection of workers. So even if there's something that isn't specifically spelled out in the statute, the employer is expected to take that proactive step in order to fill that gap and say, okay, this strikes me as something that could result in a worker getting hurt. We're not going to allow this particular type of work until we've ironed this out, or we're going to prevent this work altogether. So those are employer features. A constructor is a party that oversees a construction project and effectively coordinates all of the work. And so they have coordination specific responsibilities. They need to ensure that every employer, right, so every subcontractor and worker on the project complies with the OHSA, and that includes supervisors and stuff like that. They have to maintain overall site safety, which is broader than the responsibility of an employer, regardless of which contractor actually employs the worker. And they have to prepare and implement a health and safety plan for the entire project. So there are further responsibilities. This is just a very high level summary, but there are defined differences in the statute between employer, constructor, and owner, where this case, the way that those definitional issues came up in this case was that the city tried to rely upon the fact, as you had called out, Sahil, that it had appointed a constructor and essentially tried to cut this off at the pass, saying, I've delegated the responsibility and therefore the constructor has primary responsibility and liability. The court said, "Nuh-uh, that's not okay, not in this instance." It had contracted for the work, the city, and it had sent these quality control staff on site. And so even though it had delegated operational control, and you hit the nail on the head, Sahil, you can delegate some control, but not all, and we can still charge you, and you can still be embroiled in all of this litigation for years thereafter. And you need to actively discharge your own duties under the OHSA, regardless of who is managing day-to-day on the site. Those are my pieces, I think, on this one.
Thank you both. And I think this next question will actually directly and indirectly answer a few questions in the chat that we've received. What steps or measures are within the constructor owner's control, and what reasonable precautions should be taken? I might pass that to you first, Tushar, given your recent comments on everything reasonable in the circumstances.
Certainly, thanks, Mike. So we talked about constructors and their obligations and responsibilities. So they're responsible for coordinating the health and safety activities on the project. And then owners, particularly those who are also employers, they still have this sort of non-delegable, I don't love that word, but non-delegable duty to take precautions that are reasonably within their power, right? So now that we've come to the end of this saga, the courts have recognized several reasonable steps that constructors or owners can take. These include selecting qualified and competent contractors. I think that's probably the one that sticks out the most. With a strong track record of safety compliance, we have to ask these questions, folks. And then embedding, Sahil, this is sort of delving into your zone, and I will turn to you shortly. Embedding health and safety obligations into contracts, including specific references to OHSA responsibilities. And then there's monitoring, there's responsibility for day-to-day incident response. There's ensuring that workers receive proper training and supervision. So these aspects are informed by the outcome of the case when it went to that due diligence stage. When it comes to that exercise of embedding into the contract, Sahil, maybe you can speak a little bit about what we're doing to new contracts or existing agreements, even if we're modifying terms, and maybe the process for modifying terms. Is that okay?
Yeah, certainly. I'm going to take even a step further back to Shar before we even get to the contract. I'm going to start at the RFP process. When you're thinking of going to the market and taking the project to the market, and if you are an owner in particular, one of the things that you want to build into your RFP process is a really robust review of not just the prior projects and the good construction work and the good management work of the potential contractor, but what is also their health and safety record? Who is in charge of their health and safety? Who's on their team that has experience that is similar to your type of project? What references have you checked on health and safety? What's their health and safety management plan? Did you even ask for one in your RFP? And I say that these are the kind of due diligence questions that are going to be much more acutely looked at to verify whether whether or not after there's an incident or an accident, and the Ministry of Labor comes along and says, well, what due diligence do you even do in picking the constructor from the outset? That's the very beginning that you will be able to point out that once you get the project going, that your role as an owner and employer is not that. And that's what is very clear in the decision as well, as to what are you doing on the project? How involved are you? So I think before even looking at the contract, just looking at right from the outset, it really assists. And it's quite clear to me in having done the work both for owners and contractors, and Tushar, you and Michael could verify, but you are not expected to be on site every day running this project. In fact, the more you're trying to run the project, the more likely the ministry is going to turn around and say, actually, you have taken over the role of a constructor. So as you've interfered with the contractor's ability to perform its role as a constructor, and therefore you have taken on those liabilities. But that doesn't also mean you can turn a blind eye to it. You cannot just simply walk away. So I think it all boils down to, it then depends on the type of the project. It depends on the type of the owner. An owner who's a residential home, who's having a renovation work, is going to be very different than a public-private partnership contract that's building a new hospital or new highway. And so you have to continue your due diligence in a process that makes sure that the contractor is actually doing their job.
Wholeheartedly agree. And Mike, before we go to the next one, I think there are a couple of relevant comments in the live Q&A that maybe we can knock off because I think they relate directly to this point. So there's a question here about what could the city of Sudbury have done differently in its procurement methodology to have avoided this issue. Sahil, I think maybe we can agree on this one. I think the court has held up at least one instance where the procurement methodology survived scrutiny as passing due diligence. So the model, perhaps at least one imperfect model of something that'll pass due diligence at this point in time is relevant and evident in this case, correct?
That is fair, and I think one of the issues in particular is when you see something, do you even have a mechanism for reporting it? I think that's the bottom line. And what is your system? How is your system set up?
Perfect. And I think there's another question here. So Sandy has asked, to show municipality did their due diligence in retaining GC, how do we evaluate the GC's health and safety policy? We have no expertise in that area. If we review it, does that mean we accept/approve it? I think on the latter point, the assumption by the court would perhaps be yes. But on the first part, maybe I can speak to this. As part of this procurement process, I think the expectation is that if you don't have defined health and safety expertise, you will pull somebody in who has defined health and safety expertise, because if somebody gets hurt and then 5 or 10 years down the line, your due diligence is being put under a microscope, you want to be able to hold that person's credentials up and say, look, we had this reviewed by XYZ consultant who is a certified XYZ. And that is why, court, you should accept this as part of the due diligence defense. Can we bake any of that into contractual documents, Sahil?
You certainly can, and I think you have to be very careful that you're not setting the standard too high or the bar too high for yourself. And what I mean by that is that if you are an owner, I see a question by Kim, and Kim, firstly, thank you for joining us, Kim. One of the things that you have to be very careful and cautious about it, if you're delegating, make sure you're delegating. And number one, and number two, if the delegation is taking place and you have the contract model surrounding the delegation, you still ought to have your own safety management plan that builds into the management safety plan that you would have received from the contractor, and see how it is actually going to really work out in terms of complying with these obligations. So to start to add to your question directly, yes, you can be very efficient and effective in the drafting, but at the same time, you want to be sure that your team is aware as to what is contained within the draft and the contract that is actually signed, and not just put away somewhere after it is signed and nobody returns to it. And there could also be mechanisms built in as to, you may think something is going to work, but it may not actually work. And whether or not health and safety is an ongoing discussion, it should be at either a weekly meeting or a project bi-weekly meeting, whatever the case may be, so that the plan is getting updated and revised with the issues and circumstances as they arise.
I think that's the key from a litigator standpoint as well. Sahil, you're a litigator too. We've been in circumstances where the contract gets pulled out and somebody blows a plume of dust off of it. It hasn't been looked at since the project started in 2019 or whatever. The meetings may have been happening. The proactive steps may have been happening in the monitoring, but there's no documentation. Can you speak to the steps perhaps that we might, not part of the contract per se, but perhaps some of the documentation that we should be doing to prove that we're delegating responsibly, if I may?
Yes, so just taking the Sudbury case as example, when you see something, do you even have a mechanism for reporting it is the thing? And I think that was one of the problems, I think, in the Sudbury case. They had inspectors going on site. Their job was not to report back on health and safety. They clearly saw there was no barrier, no fence separating the project from the public, but they had no mechanism or reporting channels to go back and say, hey, we didn't see this. We were there to look at deficiency, but we noticed this, that, and whatever. So the next step is, so what's your system? And not only what is your system and how is your system set up for you to report internally to track these issues? Because once you know about it, what are you doing about that? Usually a standard of any kind of monthly progress report is a health and safety report, which includes incidents on site. Well, hopefully you've got that, but if an incident has been reported, what are you doing about that next month? Are you following up, or is it just, okay, we had it on the list, we checked that box, and we don't have to think about it? That, I say, would be a gray area / danger category.
Wholeheartedly agree. Absolutely. I think I'm informed that Michael's having some technical difficulties, so we're going to roll with the punches here. Can we move to the next slide? Okay, so this is a good question. Maybe I can start off, Sahil. So what is the practical consequence of this legal saga on owners? Can you clarify to what extent due diligence should be carried out? From where I'm sitting, I think the practical consequence is clear. So being an owner really does not shield you from liability under the OHSA, and you do need to delegate responsibly. If you meet the definition of an employer, you can be charged, right? Oh, I think we have Michael back. Perfect. And again, simply appointing a constructor doesn't end an owner's safety responsibilities. And so, what does this mean in practice, at least from an OHS compliance standpoint? We've got to have active ongoing and I think well-documented due diligence. It's not enough to simply rely upon a paper contract or say it was so in the future after there's a charge. So there are a couple of different things that I'll sort of call out just to summarize. Selecting that competent, safety conscious constructor is going to be key. Incorporating your OHSA obligations into procurement, to your point, Sahil, and contract language is going to be key. And then monitoring your compliance to make sure that the fence is up throughout your monthly inspections, reporting mechanisms, and oversight protocols. Yes, the quality control inspector is going on site to make sure you're getting what you paid for, but if safety issues are identified, they need to be dealt with, and like yesterday. So Michael, you said it earlier, an ounce of prevention is worth a pound of cure. I think it's like, 10 years of litigation's worth of cure. And again, the test is not perfection, but it's reasonableness. And the position of the owner, whether you're a homeowner or whether you're a public partnership contracting owner, the expectations and the level of expertise are different. I think the more foreseeable the hazard, the more authority or influence the owner has, the higher the expectation to act and get closer to that sort of model that the court has endorsed effectively. Anything to add there, Sahil?
I would only add one point in terms of practically speaking. At the end of the day, I don't think the rule and the obligation of the owner changes. The owner may want to make sure that it's very clear as to what role they are taking under the contract, and if they see things, then it is reported, and there's a plan to address the issues at hand. But in terms of the owner's obligation that may be going to, if inspectors is an example that we're looking at, that's going to form part of a latter task that we're going to speak about due diligence, the defense itself. If there's an incident, that's exactly where the due diligence come into play. That we under the contract and in the RFP process, we did all of these things. There's a mechanism by which health and safety was quantified on the project, and how the parties worked robustly together to ensure that the health and safety was immersed in the DNA of the project. So I think, practically speaking, it should be an ongoing dialogue on the project.
Next question, please. And just a few more, and we do have some really good questions in the chat too. I want to make sure we get to in the last 12 minutes here. So most owners do not know construction safety regulations, which is why they delegate site safety responsibilities to the constructor. Does this mean that owners must purchase more insurance?
Maybe I can take this one. So there are a couple of legal restrictions in the OHSA. Specifically, I believe it's under section 66, which states that no employer, director, or officer can be indemnified for fines imposed under the act. And so, to kind of cut to the chase, coverage may be not a firm yes, permitted for legal defense costs, for instance, lawyers' fees, civil liability claims, excluding the WSIB, of course. Directors and officers insurance might include legal expense coverage, but perhaps stop there. They wouldn't include payment of fines or penalties because that would breach the statute. EPL policies might cover some elements of compliance-related investigations and advice, but it really depends on the policy. And of course, there are guardrails. You can't go past a certain point. What can't be covered, to the best of my knowledge, fines and penalties under the OHSA or imposed by the courts or the Ministry of Labor, those cannot be covered because that would essentially defeat the public policy purpose of deterrence in this particular sector. So you can't really insure against jail time. Jail time is jail time. And of course, criminal negligence charges, if there's a breach of the criminal code via Bill C-45, a criminal negligence charge that's based on the OHSA, that can't be insured either. And so there is, you can carry coverage on certain items, but it's not really a fulsome backstop. And it's certainly not, maybe I can turn it over to you, Sahil, on this point. It's certainly not a substitute for due diligence, whether in a contract or on the ground.
None whatsoever. And I think, in my view, this isn't a relevant factor to make out a due diligence offense. Oh, I purchased exact more insurance. I think that's turning an eye to the live issue on ground. What we have been discussing, what has been memorialized through the various court decisions, is what steps are you going to take to ensure that there is no fertility, and what steps are you taking to ensure that your site is safe? I think that's the period. That's the bottom line.
I think we all know that insurance is never a full answer in a lot of circumstances. What should owners do to protect themselves? Should they avoid being on site at all or having any control over quality?
Bishar, do you want to speak about the occupational health and safety first, and then I can speak through the contract?
Certainly. I think on the ground, there was actually a question in the chat about this. Basically, should we remove ourselves from the equation? To our various points that we had discussed, Sahil, previously, that is not the solution. In fact, it can backfire, because then you can fall into that willful blindness or negligence category, and you don't want to be there. The courts don't expect owners to be invisible. They expect owners to be informed. They expect owners to be prudent. They expect the owners to be proactive and to monitor responsibly, but also to kind of stay within their lane, if I can say it that way. So I think the key is we've got to define roles and responsibilities, and that needs to be implemented, and we need to document what's happening. We've got to retain quality oversight. That's a non-negotiable. We want to make sure that we're getting what we're paying for. But again, stay within your lane. So oversight is for compliance and contractual performance. It's not necessarily for managing daily safety unless there's something egregious that sticks out. And those egregious items need to be called out. So there might be a training point there for management and QC teams. We've got to document due diligence activities, including escalations. So let's say the QC employee finds an issue with the site. There is an escalation process under the contract. We are following the process. The GC is notified. The GC does something. We close file. We've got to document those steps. We want to generally avoid, Sahil, you had spoken about sort of day-to-day control and directly stepping in. We want to avoid issuing directives as an owner, which will interfere with the constructor's safety responsibilities. But we do need to have an escalation mechanism and a channel that we can use to flag concerns appropriately, I'll say. And internal teams need to be trained on this. Oftentimes this is, folks are running all over the road. Most of the time there's no issue, but when there is, a simple email that is too direct can be problematic. And so make sure your folks are trained on the lines so that we don't actually blur them accidentally when we're on the ground. Anything else to add on that, Sahil?
Yes, I'm going to take even a step back to talk about what this actually means for the owners. There has been a industry shift in terms of the owner's view, what it was some time ago, a few decades ago, I would say, that the practice was definitely for owners to say, hey, this is my project. I'm hiring you to take care of the problems, and I want you to take care of all of those problems. And I'm paying you, and because you're going to take care of all of those problems, you are on a hook for every problem that is going to come up on the project. That practice has shifted, and we've seen a real shift, especially on much more sophisticated, complex projects, where you need to have an appropriate response. And you see this in the contracts to say that they are the parties who have the expertise, and they're the ones who should take care of that risk. And there are the parties who can control that risk better, and there's the parties that should control the risk. And most of the time, that is still going to be your contractor. And so the contracts aren't going to change that much in terms of the roles and the responsibility and the liabilities. But what you will see is that where the owner is trying to avoid even the responsibilities and the risk, that is really in the position of the control, really in the position to control the best, and therefore should hold on to, and the contract, or is in the position to take out the right kind of insurance to cover it. So when it comes down to the issue, like I've said in various answers of the question, I still see in some contracts where an owner is trying to delegate not just the role of the constructor, but also all of its roles and responsibilities as an employer. So this decision should give you a pause. And the health and safety has always been an issue. And so there's a good reason to address that head on. And you want to make sure that you're talking carefully and taking on the role properly, keeping in mind the due diligence things that you're always going to want to do on any project. In any way, to ensure that the constructors are and the contractors are WSIB certified, they have the right kind of credentials for worker compensation, whatever the regime and whatever the province, and making sure you've done your due diligence. So that's an interesting way to ensuring that you should not simply disappear. You have obligations which you cannot contract out of.
Thank you both. I am mindful of the time. I'd like to get to the there's some really good audience questions, so I think we can forego these final two questions, and
Yeah.
I'll open it up here. One particular question from Alan. While the case involved an owner as an employer, how does it apply to architects and engineers who send staff to construction sites to review and exercise a quality control role?
I can respond to that, Michael. Firstly, I make an assumption that you are a owner's representative when you are attending the site for a QC role. Since you're an owner's representative, the owner's safety management plan should talk about this issue at hand and what would occur where you, in your role as an architect and an engineer, are sending staff to review and exercise a quantity survey role or a QC role. And I presume, again, an assumption on my part, that you are doing this on a monthly basis as you perform your QC role. So having said all of that, this is where you are going to have a separate contract with the owner in your role as an owner representative. And your attendance ought to be considered within the management role, safety management role that the owner is going to have for the project. And that also have to immerse with the plan that the contractor is going to have as to what is going to take place when you are attending on site, and how does the right hand talk to the left hand. We have 1 more minute, Michael, so let's take one more question.
One more, okay. As an owner, if you have no experience analyzing health and safety programs, but rely on certification of a constructor's program, such as CORE or ISO, instead of finding an expert to review the constructor's plans, is this enough due diligence? And there seems to be concern about whether those external programs would then be useful to rely upon.
Tushar, do you want to address that one? We're out of time.
Yeah, we're right on the line here. I think the long and the short of it is, if there is a fatality and we're dealing with a very unfortunate factual scenario, the constructor, somebody has dropped the ball, right? So the Ministry of Labor is going to come on site and they're going to assess liability in every single direction. Do you want to basically be holding a card in your hand that says minimum compliance? Or do you want to prove that you have taken as many steps as you are aware of and that you think are reasonably possible? In my view, if it's my money, I would want to be on the side of having retained the consultant and taken and essentially gone the extra mile, because you just don't know when this type of a situation could come up and when that could happen. So more is better. I mean, there is no bright line saying that this is the sufficient standard of due diligence. But if I'm in the owner's position, I want to be mindful that I can take that additional step. I could be charged as an employer. And what that means is every precaution reasonable in the circumstances, including what I'm aware of. So hire the consultant, bake it into the budget. It will be a rounding error compared to the litigation costs moving through a very difficult OHSA prosecution.
All righty. We'd like to thank everybody for coming out today. We do invite you to share with your thoughts on today's session. As Sahil mentioned at the beginning, the session is recorded and will be sent out to the attendees. And on behalf of Gowling and our entire family here, thank you very much and have a wonderful Wednesday.